Welcome back to the deep dive. You know, usually when we talk about a system update, we're complaining.
Oh, yeah.
It's that annoying notification on your phone that pops up right when you're trying to call a cab, or, your laptop fan spinning out of control in the middle of a meeting. It's an inconvenience.
Mhm.
But today we are looking at a system update that is infinitely more massive. We're talking about the operating system for justice for, what, 1/6 of the world's population?
That is the perfect way to frame it.
Mm.
We aren't just looking at a dry legal text today. We are peeling back the layers of the Haratianaya Sanhita 2023, the BNS.
And the BNS.
This is Act number 45 of 2023, and it essentially rewrites the code for what constitutes a crime and how it should be punished in India.
Exactly. And just to clear up the naming for everyone, Sanhita basically translates to a code or a collection. But what stood out to me as we were going through these, 185 plus sections wasn't just the legalese. It was how much this document tries to catch up with reality. For a lot of us, the law feels like this dusty Victorian thing that doesn't know what an iPhone is or how modern dating works. But reading this, I kept stopping and thinking, wait, they actually thought of that?
It is surprisingly modern in places. We're moving from a framework that was largely established in the colonial era to something that attempts to address 21st century problems.
Right.
We have everything here, from updated definitions of terrorism to how the law treats digital documents. It's a massive overhaul.
And the hook for me, and I think for anyone listening who has ever navigated the complex, messy world of relationships, is that there is a specific section in here that sounds like it criminalizes ghosting or catfishing on a massive scale. We are definitely going to unpack that later because the implications are wild.
We certainly will.
Right.
It's Section 6.9, and it is legally fascinating, though perhaps a bit terrifying for anyone with a loose relationship with the truth.
But before we get to the relationship drama, let's start with the basics. The geography. The long arm of the law. If I am an Indian citizen, but I decide to, go on a crime spree in Paris, am I safe from this book?
You are absolutely not safe. And this is where we have to look at Section 1 of the Sanhita. It lays down the jurisdiction. Section 5 is the critical part here.
Okay.
It explicitly states that the provisions apply to any offense committed by any citizen of India in any place without and beyond India.
So the passport in my pocket carries the penal code with it. It acts like a geofence that never turns off.
Precisely. It travels with you. But it goes further than that.
It does.
It also applies to any person on any ship or aircraft registered in India, wherever it may be. So if you are on an Indian registered plane flying over the Atlantic, this law applies.
Okay.
But here is the part that really highlights that system update we mentioned earlier. Section 1, subsection 5C.
This is the digital sovereignty part, right?
Yes. The law applies to any person in any place without and beyond India committing an offense targeting a computer resource located in India.
That is huge. So let's break that down. You could be a hacker sitting in a basement in a completely different hemisphere.
Doesn't matter where.
Someone who has never set foot in India, doesn't hold an Indian passport, and has no physical connection to the country. But if you target a server in Mumbai or a cloud resource hosted in Bangalore, you are liable under the Haratianaya Sanhita.
That is exactly what the text says. It effectively expands the borders of Indian law to include its digital infrastructure, regardless of where the attacker is physically located.
Wow.
It recognizes that in the modern world, borders aren't just physical lines on a map. They are where your data lives. If you attack the digital assets of the nation, you are subject to its laws.
Okay, so the map has changed. Let's look at the dictionary, because usually when we read legal documents, the definition section is the boring part where we tune out.
Right.
But Section 2 seems to be doing some heavy lifting here regarding who actually counts as a person.
It is. Section 2 is the dictionary for the entire code. And there are some subtle but powerful shifts here. Take the definition of gender in subsection 10.
Right. Usually in older laws, he meant he and she was sometimes implied, or it was all very binary.
Historically, laws used he as a catch-all generic pronoun. But here, Section 210 states that the pronoun he and its derivatives are used for any person, whether male, female, or transgender.
Wow.
And it explicitly references the Transgender Persons of Protection of Rights Act, 2019.
So it's hard-coded, inclusive language. It's not just a judicial interpretation anymore. It's right there in the text of the penal code.
Correct. It integrates the modern understanding of gender directly into the definitions. It ensures that the protections and liabilities of the law are explicitly applied to transgender individuals without ambiguity.
That's a big deal.
Another big one is Section 2.8, the definition of document.
Let me guess, does it finally acknowledge that paper isn't the only way to write things down?
It does. It says document includes electronic and digital record. It explicitly mentions that it doesn't matter what means or upon what substance the letters or figures are formed. So a text message, an email, a server log, a digital file on a USB drive.
All documents.
These are all documents in the eyes of this law.
Which makes sense. You can't prosecute cybercrime if you don't recognize a hard drive as a document. It closes a massive loophole where defense lawyers could argue, well, it's not technically a document because it's just ones and zeros.
Exactly. It removes the friction of trying to fit digital evidence into analog definitions. Now let's move to the part that usually scares everyone. Punishment. Chapter 2.
This is where the rubber meets the road. Section 4 lists the punishments. You have the classics we expect: death, imprisonment for life, imprisonment...
Which is split, interestingly.
Which is split into rigorous and simple forfeiture of property and fine.
Just to clarify for you, rigorous imprisonment implies hard labor. You're working in the prison, whereas simple is confinement without the labor component.
Right.
But you're right, those are the classics. However, there's a new kid on the block in Section 4, Item F.
Yes, Section 4. Community service.
Community service.
That is wild to see in an Indian penal code. Usually we think of punishment in this context as purely retributive. You pay money or you lose your freedom.
It represents a significant shift in philosophy. It suggests that for certain offenses, the goal isn't just to isolate the offender, but to have them make reparation to society.
It's a restorative approach rather than purely punitive.
And practically speaking, it gives judges an option between slap on the wrist and prison sentence.
A middle ground.
Before, if someone committed a minor offense, sending them to an overcrowded jail seemed harsh and counterproductive. But a fine felt like nothing for a wealthy offender. Community service fills that gap.
Yeah.
It forces the offender to contribute time and effort, which is a great equalizer.
Speaking of prison conditions and how the state handles people, I noticed there's a lot of detail about solitary confinement in sections 11 and 12. I always assumed solitary was just something the warden decided on a whim if you misbehaved.
That is a common misconception, but the BNS is very strict about this. Section 11 says solitary confinement can only be ordered by the court, and only if the offense allows for rigorous imprisonment.
Okay, so it has to be a court order.
But Section 12 is where the human rights protections really come in.
It prevents indefinite isolation. Right. We've all seen movies where someone is thrown in the hole and forgotten about.
Far from indefinite. Section 12 sets hard caps. Solitary confinement shall in no case exceed 14 days at a time.
14 days.
And there must be intervals between those periods. If the total imprisonment is over 3 months, you can't be in solitary for more than 7 days in any 1 month.
That's a very specific regulation. It prevents the kind of psychological torture where someone is just locked away in the dark for months on end.
Exactly. It balances the severity of the punishment with basic humanitarian limits. It acknowledges that the state has power, but that power has limits. It's protecting the mental integrity of the prisoner, even while punishing them.
Now, let's talk about the crimes themselves. We mentioned earlier that this law feels like it knows what the modern world looks like.
Right.
And nothing says modern world quite like organized crime that involves technology.
There's a fascinating distinction here between organized crime in Section 111 and something called petty organized crime in Section 112.
Petty organized crime sounds like an oxymoron, like professional amateur.
It sounds contradictory, but look at what it covers. Section 112 targets group crimes that affect the public's daily feeling of safety. It lists snatching, which is a huge urban issue involving chain or phone theft.
Huge problem.
Theft from vehicle, and here's the specific one. Theft of automated teller machine.
It actually says ATM.
It specifically says theft of automated teller machine. It also includes theft through card skimming.
That is incredibly specific. So if a gang is going around ripping ATMs out of walls or skimming credit cards, they fall under the specific petty organized crime section.
Yes. It distinguishes street-level gang activity from the heavy hitters. The punishment for this petty crime is imprisonment between 1 and 7 years.
Okay.
It's acknowledging that these aren't just random acts of theft. They are organized, patterned offenses that degrade the quality of life in a city.
But then you have Section 111, the organized crime proper.
Right. This is for the syndicates. The definition is massive. It includes economic offenses, cyber crimes, land grabbing, and trafficking.
And the stakes are significantly higher there.
Much higher. If the organized crime results in the death of any person, Section 111.2, A mandates punishment of death or imprisonment for life.
Wow.
It recognizes that these aren't just isolated acts, they are a parallel system of governance that threatens society.
Speaking of threats to society, Section 113 covers terrorist act. And again, I was surprised by the definition. It's not just about bombs and guns anymore.
No, it's much broader. Section 113 defines a terrorist act as something done with intent to threaten the unity, integrity, and security of India. But look at subsection 1A.
Hey.
It includes acts that damage the monetary stability of India.
Monetary stability.
Yes, specifically by production or smuggling or circulation of counterfeit Indian paper currency.
So counterfeiting money isn't just a financial crime. Under this code, it can be considered a terrorist act.
If the intent is to threaten the country's economic security, yes. It elevates economic warfare to the same level as kinetic warfare.
That's incredible.
It's an acknowledgement that you can destabilize a country just as effectively with fake currency as you can with explosives. It destroys trust in the system, which is arguably more damaging in the long run.
That is a sobering thought. Okay, I want to pivot to the section that I teased at the beginning. This is the one that is going to get the most people talking at dinner parties. Chapter 5, Offenses Against Women and Child. Specifically, Section 69.
Ah, yes. Sexual intercourse by employing deceitful means.
So explain this to me, because to a layperson, this sounds like it criminalizes being a jerk in a relationship. But legally, what is happening here?
It is nuanced, but it addresses a very real gap in the law regarding consent. Section 69 penalizes sexual intercourse with a woman by employing deceitful means, where the act does not amount to rape.
Right.
The key here is the definition of deceitful means.
And what counts as deceitful?
The explanation below the section is key. It says deceitful means includes inducement for or false promise of employment or promotion, or marrying by suppressing identity. But the phrase that stands out is
Let me guess.
making promise to marry to a woman without any intention of fulfilling the same.
Promise to marry without any intention of fulfilling the same. That is the ghosting or catfishing clause I was talking about. If someone dates you, sleeps with you by promising marriage, but never actually intended to marry you, that's a crime now.
If it can be proven that the intention was false from the very beginning, yes.
And the punishment.
It is punishable by imprisonment of up to 10 years.
10 years? That is serious time.
It is. The law is distinguishing this from rape, but acknowledging that consent obtained through such deep deception isn't fully informed consent.
Right.
It validates the emotional and social injury caused by that kind of manipulation. It's saying that sexual consent isn't just about physical force, it's about the information you have when you say yes.
That's going to be very interesting to see applied in courts. Proving intention is always tricky. How do you prove someone never intended to marry versus they just changed their mind?
That is the challenge. Courts will have to look at patterns of behavior, text messages, maybe even concurrent relationships. It puts the onus on the justice system to distinguish between a bad breakup and criminal deception.
Fair enough.
But while we are in this chapter, we should look at Section 72. This is about the disclosure of identity of victim.
Right. We see this in the news often, where the identity of a sexual assault victim is protected.
Section 72 makes it a punishable offense, up to 2 years imprisonment, to print or publish the name or any matter which may make known the identity of a victim of sexual offenses, like rape, or the Section 69 offense we just discussed.
Unless the victim gives authorization.
Yes, or the police officer in charge authorizes it for investigation purposes.
Yeah.
But the default is strict privacy. It protects the survivor from media trials and social stigma.
Which, in the age of social media, is more important than ever.
Crucial.
Which is crucial. Now, moving from individual crimes to group violence, we have seen so many headlines in recent years about mob violence and lynching. Does the BNS address that specifically?
It does, and quite severely. Turn to Section 103 regarding murder. Subsection 2 is the specific addition here.
When a group of 5 or more persons...
Correct. When a group of 5 or more persons acting in concert commits murder on the ground of race, caste, or community, sex, place of birth, language, personal belief, or any other similar ground.
That is the textbook definition of a hate crime mob.
It is. And the punishment is death or imprisonment for life. There is no middle ground here.
Wow.
It signals zero tolerance for vigilante justice or identity-based mob violence. It takes what was often treated as a chaotic brawl or rioting and labels it as the most severe form of murder.
That is a very strong message. It says you can't hide behind the crowd. But I also noticed a slight exception in the murder and homicide sections for a specific profession, Section 106.
Yes, Section 106.1 deals with causing death by negligence. Generally, if you cause death by a rash or negligent act, like a bad car accident, the punishment can extend to 5 years.
Okay.
But look at the second part of that subsection.
If such act is done by a registered medical practitioner while performing medical procedure,
He shall be punished with imprisonment of either description for a term which may extend to 2 years.
so a doctor who makes a fatal mistake gets a lighter maximum sentence than a driver who makes a fatal mistake.
That appears to be the logic. It recognizes that medical procedures inherently carry risk and that doctors are acting in good faith to save lives, unlike, say, a rash driver who is just being reckless. It offers a degree of protection to the medical community against the fear of heavy criminal liability for accidents. It's trying to prevent what we call defensive medicine, where doctors are too scared of jail time to perform necessary but risky procedures.
That makes sense. It's protecting the function of the healthcare system. Finally, let's talk about the state. Sovereignty. There was a lot of talk about sedition laws being outdated, colonial tools used to silence dissent.
A lot of talk.
What does the BNS say about that?
This is found in Section 152. Act endangering sovereignty, unity, and integrity of India. It penalizes acts that excite secession or armed rebellion or subversive activities.
Subversive activity sounds a bit broad, though. Does this mean if I criticize the prime minister or new policy on Twitter, I'm in trouble?
No, and the text is very specific about that. The explanation clarifies what is not an offense. It says, comments expressing disapprobation of the measures or administrative or other action of the government with a view to obtain their alteration by lawful means do not constitute an offense.
Disapprobation. That's a great word. I'm going to use that. I express my disapprobation of this traffic. Basically, it means disapproval or criticism.
Exactly. So, criticizing the government, campaigning to change a law, or vehemently disagreeing with a policy, as long as you're using lawful means and not inciting armed rebellion or secession, is explicitly protected.
So it draws a line.
It attempts to draw a clear line between political dissent, which is healthy, and treason, which is not.
So we have covered a massive amount of ground here. From international hackers and petty organized crime involving ATMs to relationship fraudsters and mob violence. What is the big picture takeaway?
The big picture is that the Bharatiya Nyaya Sanhita isn't just a translation of the old laws. It's a recalibration. It is trying to catch up with technology via the digital document and cybercrime sections.
Right.
It is trying to address specific social ills, like mob lynching and deceptive relationships, that the old code just didn't have the language for.
And it's trying to be a bit more humane, or at least more nuanced, with the community service and solitary confinement rules.
Precisely. It balances the iron fist of the state, seen in the organized crime and terrorism sections, with a more modern, reformative approach in other areas. It is a complex document for a complex modern nation.
It certainly is. And it leaves me with one burning question, specifically about that community service clause we started with.
Okay.
We know Indian prisons are notoriously overcrowded.
They are. It's a systemic crisis.
So here is the thought I want to leave you with. Now that community service is a legal option, are we going to see a genuine decongestion of prisons? Will judges actually use this power for minor offenses, or will the system stick to what it knows, incarceration? The tool is there now, but a tool is only as good as the hand that wields it.
That is the million-dollar question. The law is on the books. The implementation is the next and perhaps harder chapter.
We will have to watch and see how the courts interpret this new operating system. Thanks for diving deep with us into the Bharatiya Nyaya Sanhita. Stay safe, stay legal, and we will catch you on the next one.